Now, on Friday, 29th of May 2015, 4 young Kenyan men, namely Boniface Chuma, Ravi, Gagda, Peter Muriuki, Anthony Kerr and Anthony Mwadime, who are living and working for gain in South Sudan in a company known as Click Technologies, were arbitrarily arrested by National Security of South Sudan. No charges were preferred against any of the 4 men who were confined in a military camp subsequent to the arrest. After close to a year later, the 4 Kenyans were presented to court on the 20th of February 2016 and charged with various crimes which include forgery, insult to the person of the president, misappropriation of funds among others, and bail per person set at 14 million United States dollars. The lawyer on record for the accused persons, Kirchol, was forbidden from meeting with them except on days when they will appear in court. The families engaged the Kenya Human Rights Commission seeking their intervention in the matter. To date, the Kenya Human Rights Commission has been actively involved in confronting government agencies and agents concerned, creating awareness on mainstream and social media, and holding continuous engagement meetings with partners, organizations, and members of the affected families. And you can see on screen their faces as well. Their families were holding vigil on Monday actually, yesterday and today, and this will continue until the Ministry of Foreign Affairs badges and actually respond to their plight. Their family members are still in South Sudan, and this is 2 years on, and they've been imprisoned for life. They've actually given the life sentence to 72 years. And this is the basis of our discussions we're having here this morning, amongst a raft of other issues with our panelists. I have with me, I'm holding court with Professor Noah Midamba, who's the Vice Chancellor of KCA University. Also, we do have with us Captain Collins Wanderi. Captain Collins Wanderi is an advocate and also a security analyst. Also, we do have with us Dr. Apollos Machira, is a criminologist from Egerton University. And we do have with us as well Dr. MUSTAFA YUSUF Ali, who is a conflict resolution, and also he is a national security expert. Gentlemen, you've been following this particular story since Monday. And of course, also it was quite a whippy-teary moment that we had also with some of our family members who were here on MLive to give us an account of what is happening right now and how the government has been, slow on the uptake to respond to this particular plight of the family members. I don't know if we have that particular clip we can play, and yes, just for our viewers to get an understanding of where we're coming from.
7 p.m. on Monday night, families, friends and relatives of the 4 imprisoned Kenyans in South Sudan are outside the gates of the Ministry of Foreign Affairs for a night vigil. White candles were lit, songs and prayers were conducted. Expressing their pain and dissatisfaction with the state after 2 years wait for government intervention to have their kin released from the foreign jail. The 4 families whose relatives are serving 72-year sentence each in South Sudan want the state to act now and have their kin released in the foreign jail. They have accused Ambassador Amina Mohammed, the Cabinet Secretary for Foreign Affairs and International Trade, of ignoring their petition to have their kin tried fairly and deny them information regarding the Kenyans who were arrested on May 29, 2015 by the National Security Service of South Sudan after working in the country for almost 2 years for the company owned by President Salva Kiir's brother-in-law, John Oguo, who is also a politician. The families have vowed they will continue to have a vigil every night at the office of the Ministry of Foreign Affairs until the state listens to their cry and have their kin released. Steve Juma, NTV.
Right, so we continue with that particular discussion. Let's hear from you, Captain Collins Wanderi. Why do you think the government has been slow on the uptake? Of course, we can see, yes, there's a court case continuing here, but we've not been given also the timelines. We've not been given, it's been 2 years on, and the family, they do not know the whereabouts of the members in South Sudan.
Debarl, let's first correct the impression that the government does not know. The government knows. Yesterday, the ambassador of Kenya in South Sudan did meet the 4 people in where they incarcerated in Sudan, and there were pictures in the media. However, let me say this. This matter, Debarl, is very sad because it has been mismanaged by several players who are involved in it. And this mismanagement has played onto the gallery to the extent that there has been a loss of focus on exactly what should be the solution to this matter. Number one, this matter is no longer in the hands, in the Kenyan law as it is today, this matter is no longer in the hands of the Ministry of Foreign Affairs. It is now under the docket of the Attorney General and the State Law Office. For the reason that, however much we may question the competence of the authorities in Sudan in terms of granting a fair trial and hearing to the accused persons, these people have already been convicted and sentenced to jail in a foreign country. And once that then happens, the only way of reviewing that decision or reversing the decision that put them in jail is by again approaching the appeal process in the competent authorities of that country. But what we've seen consistently in our media is a situation where there is misadvice to the family, and the family has been misadvised to the extent that instead of addressing the issue to the right office in Kenya, they are involved in attacking the processes, the legal system and the processes of a foreign country. You don't do that kind of thing in public international law and in diplomacy, because you will have to depend on the very, very systems to reverse or review the decision that was made in that country. Nations relate together on the doctrines of mutual recognition. There is also the doctrine of respect, and there is also the doctrine of reciprocity. The government of South Sudan had these people arrested. If the process of arrest and trial and the trial and the subsequent hearing of the case was a problem, then what the family would be saying and focusing on is the disregard of the rights of the international of the rights and the international standards of a fair trial, as captured under Article 14 of the International Covenant on Civil and Political Rights, instead of attacking the system and the government of South Sudan. Reason being that the moment you do that, then you lose the other side of diplomacy, where once people have been convicted, the best thing that you can do is the country, that is Kenya, can request that those people come and serve the sentence in this country. And under the Transfer of Prisoners Act 2015, if they come here, then the president has the power to even exercise amnesty and pardon on them. But what we are seeing now is a total shift. You know, people not understanding that once you convicted, that matter now no longer lies with the Office of the Minister of Foreign Affairs, but with the Office of the Attorney General.
Thank you. Let's hear from Dr. Apollos Machira.
What Collins is saying, we have no bilateral agreement with South Sudan to exchange prisoners. So that may be a little bit difficult. Remember, this case involves 16 people. 12 of them are South Sudanese. So we are now talking about 4 Kenyans who were arrested with others in South Sudan, and they were convicted each for 72 years. So we have differences with South Sudan. South Sudan is a very young country. Its criminal justice system is very young. Its prison service is very young. So when we complain that the conditions in which they are living in prisons in Jumba, that is the prisons in South Sudan. Just the way like someone from Netherlands would complain that he is convicted in a Naivasha prison or in Kamiti prison because our systems are not as good as Denmark or Holland. So it is a bit complicated for us as Kenyans. So as we approach the issue, let us know that South Sudan is a sovereign country. The people were, I understand, they were convicted for misappropriation of $1.5 billion, or I don't know what. And then they were also accused of making the seal of the president. And amongst these 12 people who were arrested, who are South Sudanese, one of them is a senior politician, and they are related to Salva Kiir. He's a brother-in-law of kind of. So you see emotions for the president as a person with his brothers. So we do not know the politics involved in that. Because when people go making seals, because these were working with the creek, and some of them were very good in technology. So as much as we sympathize with them, let us also remember that South Sudan is a republic of its own. So we need to have that quiet diplomacy, what as Amina has been doing. So we cannot say let them be released overnight, because we do not know how the South Sudan feels itself. So for me, we sympathize with them, but that the law takes its own course.
But you know, we have bugbears and figures as Kenyans, because in Ethiopia also we had Zak, who was arraigned, no, he was not even arraigned in court, he was jailed, and after that he died. And we've not seen any intervention that was done, you know, from the embassy or the Ministry of Foreign Affairs as well. So when we say that we do not know what they're exercising is quiet diplomacy, how sure are we they're exercising quiet diplomacy? And what do we mean by quiet diplomacy anyway?
I think during the recent past, we were very, very busy canvassing for Amina to be the chair of AU. So most of the things we kept aside because we were very busy going through the continent, campaigning for her to be the chair. So maybe now we shall concentrate with those 4 people.
All right, Dr. Mustafa, don't you think 2 years is such a long time?
It is.
We're talking about silence or quiet diplomacy.
It is a very long time, and this is a tough one, Debarl. One of the things that we need to recognize here is the issue of jurisdiction and sovereignty. And it's very difficult when a Kenyan national has been convicted in another country for the government of the day to intervene and have those nationals returned. There are many Kenyans who have been convicted in China for drug abuse, in Egypt for trafficking. Some of them have actually been hanged in those countries. Mm-hmm. Now, in this case, because of the young or very new criminal justice system of South Sudan, errors might have been made in terms of convicting these Kenyans. And therefore, perhaps what Kenya could do is to request the government of South Sudan to review the case, or even ask for these facts so that these facts can be reviewed. It's possible that these Kenyans are not culpable, or they might be culpable. And if they are, then these are issues that can be handled in 2 tracks, as Collins is saying, through the Office of the Attorney General, or politically, where the Kenyan president may request the South Sudanese president to exercise his prerogative for mercy to release those Kenyans, and that the case can be reopened, and if they are culpable, then they can be convicted and be jailed again, whether it is in South Sudan or here in Kenya. But it is a very difficult case. I don't think the Foreign Affairs Ministry can do much at this point, other than requesting the counterparts in South Sudan, the Foreign Affairs Ministry, to request the president perhaps to exercise his prerogative for mercy. Yeah.
So while they were actually having their night vigil, should they have been also maybe at the South Sudan embassy or the Kenyan embassy, the Ministry of Foreign Affairs?
Actually, they should have been at the State Law Office.
The State Law Office? The
State Law Office in Kenya, because under the new act which was passed in 2015, it is the Attorney General who is now seized of the matter. He can request the competent authorities in the Sudan to have because these are already convicted people under that law. He can either request, as Dr. Mustafa is saying, for a review or an appeal. Yes. But then the Ministry of Foreign Affairs should also now be engaging in diplomacy and soft power. And Kenya has the ability to engage the South Sudan on soft power because we have bilateral relations. And I want to correct Dr. Machira. In 2016, the Attorney General's department, that is the State Law Office, did draft model agreements for the transfer of prisoners between Kenya and other countries. And they only need to engage on that with South Sudan. Because if what they have been convicted for in South Sudan is also an offense in Kenya, then you can have them serve the sentence here. And that has been recognized. And Dr. Mustafa Ali also talked about China. In fact, the vice chair of the Chinese Law Society has been in Kenya at the behest of his government to negotiate with our Attorney General on the transfer of prisoners between Kenya and China. And that is what raised the attention to the draft of the model agreement for the transfer of prisoners between Kenya and other countries. And the reason you do that, as Dr. Mustafa is saying, is that once there has been a conviction, and you cannot then interfere. You know, there is also the doctrine of non-interference between nations. You cannot then start questioning. The moment you start questioning the legitimacy and the competence of organs in a foreign state, what you're telling that foreign state is that you are not like us. Your systems and processes are not robust like us. And once you go that way, then even diplomacy will fail.
All right, let's hear from the expert of foreign policy and defense.
Debarl, I agree with my colleagues here, but this problem is much more complex than we can just see. So let me set the stage for the trend here that will justify the complexity of what we are seeing. May 2014, James Gadet, spokesman for South Sudan opposition leader, was deported from Kenya back to Sudan. Immediately, Machira associate issued threat to all Kenyans living in Jonglei, Unity, and Upper Nile. In 2015, 5 Kenyans were actually arrested and detained in South Sudan for stealing $200 million. This was an international crime which involved even the Central Bank of Kenya. In June 2016, the 4 Kenyans we're talking about put in prison for stealing 1.5 billion shillings from the president's office. In January this year, Kenya authority detained 2 critics of South Sudan. There's a lawyer, human rights, Agre Idri, and Dog Samuel. And in January this year, Deputy Governor of Bwe State issued an order to detain and prevent any Kenyan from escaping within their territory.
Yes.
So this matter is becoming much more complex than what your eye can tell you. First of all, were these real criminal? That's number one. Did they receive fair trial? South Sudan is an independent state and a very volatile one at present time. Any louder noise toward them is not going to help the case of these people. Like Captain Wanderi say, we need to be able to use all the instrument possible, president to president, the court system connected together, the diplomatic angle, in order to try to bring these people back and put them in our own prison, or retry them in our own prison. But we cannot shout louder and say we demand that these people return to Kenya. But they may not return alive. That is the kind of thing that we need to understand.
All right. Isn't what really happened in Ethiopia, should it be a learning experience for the country?
Yeah, you see, these kind of situations have not only happened in our country. In the Attorney General's office in Kenya, I'm aware, was approached by Pakistanis who are convicted in Kenya for drug trafficking in 2016 for them to be transferred to serve their sentences in their country, which under the United Nations agreement or model agreement on the transfer of prisoners is very clear that you need to let people go and serve sentences for social rehabilitation in countries where their communities are. And remember, when those people are moved to those countries, then the authorities in those countries can even exercise the power of pardon and amnesty. And that is the beauty of it. It was a very sad situation that we let our Kenyan die in Ethiopia, because consistently again I saw a situation where everybody was focusing on the Ministry of Foreign Affairs, whereas the power, the rightful authority now is that office, is the state law office. But let's go further and see what happened elsewhere internationally. In Nigeria in 2002, a young woman called Amina Lawal was convicted of adultery under Sharia law. And it raised a lot of attention internationally in the media. And I remember the then president of Nigeria, Olusegun Obasanjo, saying he may not also interfere with the court system because, as the professor is saying, it's an independent country with its own systems and is a foreign jurisdiction. But what did the president promise? He said that we'll, as a state, will explore all avenues of law and the court system. And so the matter went to the Higher Court of Appeal, which upheld the sentence. It also went again to the Court of Appeal in Katsina in northern Nigeria. And at that point, the questions that I have raised on the issue of whether the trial complied with Article 14 of the International Covenant on Civil and Political Rights became at play. And again, the president of Nigeria had advised the Amnesty International and other non-governmental organizations to stop attacking the personalities of the judges, but to focus on the trial itself. And finally, what the court did on appeal is look at the technicalities and released Amina Lawal and set her free. And this is what we should be focusing now. And once again, I repeat that anytime a person is convicted, the family should not be misadvised to keep harping at the Ministry of Foreign Affairs, but to approach the state law office. Because if you remember, even when we talk about extradition of criminal fugitives from Kenya to other countries, it's not the Ministry of Foreign Affairs that is involved. The proper office is the state law office.
Yes.
Yes.
All right, let's hear from Dr. Apollos Machira.
You see, me, I'm worried about this case. We have other 12 Sudanese, South Sudanese, who are also serving the same period. If these guys are released, what will Salva Kiir do with the other 12, who he hates personally, at that personal level? So unless the president himself, Uhuru, talks to Salva Kiir directly, these are the things which shall be going round and round. So is quite unfortunate. Remember, we are talking about South Sudan. The prison is a military prison. The national security intelligence is military. So everything they do is military. And that's why a lot of our prison officers here from Roido have gone to South Sudan to train those people. A lot of our lawyers are in South Sudan to train those people because the people are not trained. So let us know which country we are dealing with. We are not dealing with an advanced country. We are dealing with a bush country that is coming up. So perhaps we can appeal to the president now to take it up.
All right.
Yeah.
Okay, Dr. Mustafa.
Yeah, I mean, as Apollos has said, we are dealing with a very young criminal country with a very young, inexperienced criminal justice system. I imagine if these Kenyans were jailed in the United States of America, I'm just wondering whether we would have had this kind of discussions here today, and probably not. And the reason for that is because we do know that the United States of America has very robust criminal justice system. And Kenyans would not question, or families would not question, the Kenyan government would not question the culpability of those who have been jailed. There are many Kenyans who are in the US jails. Now, the question with South Sudan is different because it's possible, because some of those people who purportedly did business with those Kenyans who were jailed are sons or relatives of the high and mighty in South Sudan. It's possible that they were framed. And it's possible that the investigators in South Sudan did not want to investigate matters where the sons of prominent individuals or political leaders or military leaders in South Sudan were actually involved, and therefore then just hush this case and put those Kenyans in jail. I think the best way is to have this case reviewed by competent authorities. Kenya should offer perhaps its own investigators to South Sudan, which then needs to be accepted by South Sudan because of issues of sovereignty and jurisdiction, and then have this case reviewed. If they are found guilty, then they should serve their sentence. If they are not found guilty, then they should be set free.
Thank you. We have callers who are hanging on the line. We have Mathenge first up on the line. Good morning, Mathenge.
Good morning, asubuhi.
Mzuri sana.
Okay. Nasikia mambo, kwanza nilikuwa nataka nirudi nyuma kidogo tuende kwa mambo ya Mr. Kaparu, mambo ya NCIC. Mimi nilikuwa naona hii pesa ambayo anapewa Mr. Kaparu. Kwanza nataka kujua yeye yuko na wafanyakazi wangapi katika ofisi yake ambayo hiyo pesa inaenda bure, kwa sababu hiyo pesa ingeongezwa katika mshahara wa madaktari, kwa sababu hiyo pesa kuna kazi inafanya tafadhali. Alafu tukirudi kwa upande huu mwingine wa watu ambao wamefungwa upande wa Sudan, Ngoja nikwambie kidogo. Wacha mambo ya corruption. Kama mtu amepelekwa mahali kufanya kazi na ameaminiwa, amepewa kampuni anafanya kazi na apatikana ameiba, hao watu wameiba. Wapacha wapate kifungo, ndio mambo ya corruption, mambo ya wizi ikome. Tusitetee watu ambao wamedhulumu wale ambao wanafanya kazi. Tafadhali.
All right, we have Simon hanging on the line as well. Good morning, Simon. Yes.
Yes, I'm glad about the conversation that is going on.
Yes, thank you.
I want to talk about the peace in the country, whereby you see there is a lot of crime. Actually, we'll talk about crime in general. And it's good that the panelists are wondering why there are so many commissions doing almost the same thing. And then I want to say this, that the Kenyans should have a program that helps them to learn about the ethics and the nationalism and patriotism. You see, there are those gaps. We come in to try to rein in Kenyans like we are actually on the defensive other than going out proactively. You see, like NCIC is working very hard to go out and look for hate mongers. You don't go out to look for a hate monger. You should train the children to grow up knowing that they respect one another's property. We are one nation. Other than going out to chase them, catch this one and take them in. Whom are you going to chase? Because those hate mongers are very prominent, powerful people in the community. But when they were children, they were left like that, and they grew up.
Thank you.
And now you see what is going on. Can we have a commission or even a curriculum in our education system that has ethics? Ethics, ethics. Let us humanize Kenyans. Kenyans, to me, they look like animals. By the way, I'm a counseling psychologist. Thank you so much.
Thank you, Simon. From Bungoma there, we have also Pepe hanging on the line. Good morning, Pepe.
Morning to you. How are you?
Very well.
I have a comment and a concern about the Kenyan fall. My question is, why were their lawyers intimidated? Because I was following it up since yesterday, and remember there's a family member who said that the first lawyers were intimidated and they pulled out of the case, and the second one even was held at gunpoint. Correct me if I'm wrong. Yeah. Why were they doing that to make sure that nobody's there to tear how? I think there's a sinister motive. And kindly, these are brothers and sisters to somebody. These are family members. I feel for the family and I feel for the desperation. Kindly, if the country can, if the government can do something about it, kindly get into it.
Thank you.
Okay.
Thank you.
Yeah, we would really, really love them to intervene in this case because I feel there's a sinister motive. I feel these are people who are victims of circumstances. They were used to do the fraudulent deeds, and they didn't know. So they're just paying for somebody else's. Yeah, right. Kindly.
Thank you.
Because I don't feel this is right.
Right, thank you, Pepe, from Eldoret, excuse me. And of course, she's raised a very pertinent issues. Of course, issue itself that the lawyers were intimidated. And they dropped out of this case. And I think also we need to be a bit sensitive. We cannot say that they stole or they did any shoddy business in South Sudan because this is also under investigation. So we cannot claim that they're guilty, as Mathenge was alluding to as well. So she says there's a sinister motive in this. Do you also level with her on this? Do you read any mischief 2 years down the line? Why were the lawyers intimidated? Why did they dropped out of this case completely? So as it is right now, we don't know if there's any investigation going on or there's any judicial process that is being meted out for this particular Sudan 4.
Debarl, it is quite true and it is quite clear from the entire process of trial, from the time these people were arrested by the National Security Service in Sudan. They were not arrested by the police, but by the National Security Service. My colleagues have alluded to the fact that some of the players in this whole game were either relatives or close associates of the president, of the current president of South Sudan. So that raises a lot of political tension and passions in that country. But I want us to also treat this matter with the seriousness it deserves. And we look at the intricacies surrounding it. Now, during the trial of these people, if you are accused of something that involves the president of a country, and it is being, the whole process is being driven by the National Security Service, which is the intelligence service of a country, then you would have a lot of things that do not necessarily follow the normal protocol of a trial, which involves the police and the entire criminal justice system. And this is why we've said, if you look at Article 14, it clearly spells out what constitutes a fair trial. There was no there is coercion, intimidation. In fact, there have been reports that in fact the charges were read in Arabic and they needed to be translated. That legal representation was denied after the conviction at the High Court. The Supreme Court of South Sudan was required to confirm the charges because of their seriousness. And then there is, of course, the appeal process. And whether the trial was not even prompt, because that's also a condition. These people, if your charges are read in Arabic and people are speaking in Arabic, you may not even be able, as the accused person, to listen and interrogate what the witnesses are saying. So there are a lot of things that haven't gone right. But having said that, let's look at it. Dr. Machira has consistently, and it is true, that there were 16 people convicted. 12 are South Sudanese. Now, whereas in Kenya, when we were tweeting about our people in South Sudan, I also made a point to look at what the South Sudanese nationals were tweeting. Actually, they were expressing happiness and support for their country for charging these people and jailing them. You must be very sensitive to that. That whereas we as Kenyans, we must be sensitive to the social and political and communal sensibilities and sensitivities of the people in South Sudan. It is their country that had lost money. It is like telling Kenyans that if a foreigner was involved in NYS loot, which has brought a lot of tension here and passion, that we should then let the foreigners go. No, that is not the way people in South Sudan viewed it. They viewed it that their government had done right for charging these people and convicting them. And we must look at that because we have 12. And this is why I'm advising that, in my opinion, that even as our president intervenes, as the Minister of Foreign Affairs intervenes, the best way out of this is to have these people transferred, because there is a legal way of doing that, to serve their sentences in Kenya. Now, under the UN model, you are not going to reopen the trial in Kenya. But however, you can raise attention and look at the record whether it complied with the standard, the international standards of a fair trial. And if it did not, then you can make presentations to the president of the country, because if they are transferred here,
of which he doesn't,
the president can then exercise pardon and amnesty, and it has happened in other countries.
But going through the rigors of what you're saying, if it's a fair trial on international standard, it has failed dismally, isn't it?
Even if it has failed, unfortunately, even if you wanted to review and reverse the conviction, you would still have to depend on the competent authorities, which is the judicial system of Sudan. As I explained, that even in Nigeria, it is the court in that country that had to reverse that very sentence that was meted out on Amina Lawal in 2003.
Right. I can allude to the fact because I spoke to one of the mother of actually Wanderi, and she told me clearly, yes, that particular sentence was read in Arabic, and it took actually a long time for them to try. They had promised they actually translate that, of which it never happened. So they don't know what they were responding to in the first place.
Yes.
Okay, let's say from Professor Noah Midamba. So what should be the way forward right now?
I think Captain Wanderi is really right from the legal standpoint. Was it a mistrial? Were there really evidence to convict these people? Did they really steal 1.4 billion? Is it conclusive? That kind of thing. Now, the issue is the question that we may ask, as I think it was MUSTAFA alluded, if these people were locked in America, there will be no issue. The issue that we are concerned about is whether or not these people got fair trial. We are not arguing that they did not steal. Okay, that is not the issue. So how do we go about it? I will go exactly with what Captain Wanderi is going, talking about. Our judiciary, our Attorney General's office need to be connected directly with the Sudan quietly. Then the same thing with our quiet diplomacy. The same thing with the president, intervening directly with the other president, such that these people can be moved into Kenya and trial, or the president give them pardon. That is the only solution. But we cannot sit here and judge what other nation state does, whether it is in Pakistan or whether it is Nigeria. The point is, when a Kenyan go, there are many, many Kenyans who are either teaching in South Sudan or engage in business one way or another, lawfully. These are lawful people who does their business and return to Kenya. There is a reason why these people are in jail.
Right. I just want to read one of the tweets that we have also from Patrick Cabras, is saying, why can't the Attorney General handle this case with zeal and power the way he did with the president's case at The Hague? Right, you want to respond to this? Because yes, why can't they pick up this? We saw the two of them arraigned in court at The Hague, the zeal and vigor that they dedicated to this particular case. Why can't we commit this to these dear Kenyans who are in South Sudan?
You know, The Hague is an international court using international standard. But here in South Sudan, remember when the family,
no, we cannot have that argument. We've crossed the boundaries.
Yeah.
Once we cross the boundaries, we become international. It doesn't matter if it's an international case.
When the family members visited trying to know what happened, they were also told that they will also be put in jail. In fact, when they talk, you can see the agony with them. When the Kenya Human Rights Commission also went, they visited the prison. They also started crying because of the life in a South Sudanese prison. So we are dealing with a country that is, you know, that is a developing country. So they behave differently. The National Security Intelligence, once you go to ask why your brother has been arrested or why your wife or why your husband is there, you also don't ask too many questions, because we are also going to put you in. The lawyer was threatened with a gun in front of a judge. So you can see the nature of that country and their criminal justice system. So he cannot compare this with The Hague.
All right.
I think by 2015 October, Kenya had 3,000 nationals jailed in foreign countries. And this is why the Attorney General, in his wisdom, said that they must then draft model agreements for transfer of prisoners.
Yes.
There is a reason why we do not want to sit here, as Professor has said, start questioning the legitimacy and competency of the authorities in Sudan. And because of the intricacies of this, we have to look for a solution and a way out. The Attorney General's office, and this is, I want to emphasize on this, should, in fact, what that person who's tweeted is right. You know, because under the Act, the Attorney General does not necessarily need to do this. He can delegate his power to the Solicitor General under that Act. He can delegate the power even to one of the Deputy Solicitor Generals. So all we need is to see some action that the Attorney General's office delegates this issue to one of the many Deputy Solicitor Generals in his office to directly deal with this issue and engage the authorities in South Sudan, whereas the Ministry of Foreign Affairs and the Presidency play soft power and diplomacy. Yes.
Thank you. Okay, let's hear from Dr. Mustafa.
Debarl, I didn't know until Captain Collins Wanderi said that there are about 3,000 Kenyans that have been convicted in foreign countries, and I think that begs the question. 3,000, population of 45 million, that's a very high number. Yeah. Yes. And we need to ask ourselves this question: are we a nation of crooks? That's important. Now, with respect to ICC and South Sudanese courts, these are two very different jurisdictions. ICC has global jurisdiction. It has jurisdiction over Kenya. South Sudanese court has no jurisdiction over Kenya, neither do the courts in Kenya have jurisdiction in South Sudan. And therefore, still this makes it very difficult and a tough case. And I think the only thing Kenya can do at this point is to ask for a review of this case. And it still appears that there was no fair trial in this case. And therefore, I don't think it would be disastrous or a threat if South Sudan courts would even set these Kenyans free and continue continue retrying them. They can still keep them in South Sudan until the trial is finalized. But that this case needs to be opened, I think.
But listening to Captain Wanderi, he says there's a provision that actually these cases can be transferred to Kenya for them to be tried here. The prisoners, the prisoners can be transferred to Kenya to be tried here in the country.
And it is in Kenya's interest, actually. If we have 3,000 Kenyans that have been jailed in courts outside the country, I think it's also in Kenya's interest to have this case transferred here. And if they are found guilty, perhaps they should just be then locked up.
Yeah, but what is really appalling, as we're winding up on, we'll also solicit your headline thoughts on this, is the fact that the Ministry of Foreign Affairs has been mealy-mouthed about this, even not really telling the family what is really happening, just to let them know at least we are pushing the envelope. This is where we've reached. 2 years down the line, you don't get any response from the Ministry of Foreign Affairs in this regard. Do you think maybe in terms of public relations also, we need to improve there? Any of you can answer.
Not just public relations, Debarl. I think the families of those Kenyans who have been locked in South Sudan have the right to be addressed. The Ministry of Foreign Affairs should meet with them, comfort them in the first place, whether their relatives are guilty or not, and then tell them what the government is doing. I believe the government is doing something about this, but this needs to be communicated privately to the families.
Thank you very much.
I think, Debarl, let's say this, that let also the government and the Ministry of Foreign Affairs not play public relations with this matter. Yesterday, there were pictures of Ambassador Leshore in South Sudan meeting with the 4 people.
Yes, I saw it.
Yes, but if you look at, because I've seen these people already convicted, if the State Law Office gets engaged, the Transfer of Prisoners Act requires the Attorney General to, in writing, keep updating the family on what is going on in the process.
Exactly.
And you are right to the extent that if the Ministry of Foreign Affairs was seized of this matter, they then would have told these people have been convicted, let's approach it from the State Law Office. From there, we would have taken it. But it's wrong for the ministry to just have photos, whereas we are talking about the liberty of Kenyans who went to seek a livelihood in a foreign country.
Thank you.